For no? Okay. All right. Court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right. And you're Miss Settle? All right. We were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All
This
right.
is where the courtroom's air gets heavier. Judge Boyd isn't just looking at a defendant on paper, she's looking at a human life, a mother, and the ripple effect of addiction. Notice how he says, on the surface, you should be going to prison. That's the legal baseline. But then, he opens the door to possibility. Judges rarely admit in open court that something looks prison-bound. That's a warning shot to the defendant, and a suspense cue for us as viewers. The question now, is this redemption arc believable, or just another performance before the gavel drops?
All right. So the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case. And when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they're able to accept her and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about...
The prosecution isn't pulling punches. They're reminding the court, and us, that this isn't Elizabeth Settle's first ride at this rodeo. Prior leniency was offered, and she blew it. That's a dagger in her credibility. But notice the nuance. The prosecutor still admits she's showing genuine changes. This tug of war between hope and history is the essence of criminal law. Should society risk another chance on someone who's burned bridges before? Or does compassion demand we acknowledge people can change? If you were the judge, would you gamble on hope or lock the door on trust?
They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency in treatment and was offered that leniency in treatment and turned it down and returned directly to that life. And so it's not just Miss Settle the state is concerned about, but it's Miss Settle's children, it's Miss Settle's family, and it's Miss Settle's community, many of which were victims of Miss Settle. And that is the reason the state is opposed. But the state is cognizant of what appears to be genuine changes in Miss Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? Mm-hmm. And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI. Back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling in programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And
this moment is pure drama. Judge Boyd throws down an ultimatum. I can sentence you to 3 years right now, or you can take this deal. Notice what he's doing. Tightening the noose, but leaving a lifeline. Deferred adjudication on one case, conviction suspended on the other, but with the looming threat of 20 years and 10 years if she fails. This isn't mercy. It's controlled risk. A sword of Damocles hanging overhead. The brilliance? It forces the defendant to weigh every decision in her future against a potential decade in a cell. Would you take that deal or roll the dice with prison?
And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right. Anything you wish to add, State?
Judge, the state stands by its concern about Miss Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for a very structured supervision, because I do believe that it is a necessity in Miss Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise,
this moment is pure drama. Judge Boyd throws down an ultimatum. I can sentence you to 3 years right now, or you can take this deal. Notice what he's doing. Tightening the noose, but leaving a lifeline. Deferred adjudication on one case, conviction suspended on the other, but with the looming threat of 20 years and 10 years if she fails. This isn't mercy. It's controlled risk. A sword of Damocles hanging overhead. The brilliance? It forces the defendant to weigh every decision in her future against a potential decade in a cell. Would you take that deal or roll the dice with prison?
The plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right. So normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, ma'am.
All right.
Judge, on the second degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
Okay. So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession of the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settles, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count 1 or 2?
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge,
Yes.
here's that docket back, and we initialed the plea bargain change.
All right. Thank you, Hunter. All right. We're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is the run concurrent with 2024 CR 01390. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's a $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please, no contact, did you say no harmful or injurious?
No harmful or injurious contact with KPEC, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state, Judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, 200 hours of community service restitution, The court will show that 100 hours is satisfied upon the completion of parenting classes, GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well. Field visits.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself 2 questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
Thank you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. So Hunter, how's it been going?
Been good.
No, I don't have it. All right. So first things first. It's on page 2. First things first. Why were you late for court? Court starts at 9 a.m.
You like that one, but I was in court, pero no me, but I didn't give my name, but I was here.
No, I call the docket at 9. And when people answer the docket, then I check them off as having appeared. But you're scheduled for jury trial today.
That's correct, Judge. We filed a motion for continuance on this.
All right, as soon as I get the file, we'll see about your motion for continuance. Okay. Okay. All right, the court is calling 2025 CR 002807, State versus Angel Cepedes Rhonda. Can I have parties announce?
Ashley Jones for the state.
John Reitmeyer for the defense.
All right, and are you Angel Rhonda?
Yes,
All right, we have an interpreter. If the interpreter could raise your right hand, do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right. Defense, you filed a motion for continuance.
We did, Your Honor. In getting ready for trial, we've subpoenaed several records that we haven't been able to receive yet. One of them, we were told the staff is not back from summer vacation. The other one, they have paused our request and sent it to the Attorney General's office for review. for open records. We've had issues getting witnesses that could help the defense due to several fears that they may have about coming forward. With that said, we did receive a late disclosure from the state about 404B evidence that I haven't had time to go through. There's also been another late upload to e-discovery that I was able to look at. I have talked with the state. I don't fault them for the late disclosure, but.
Well, now, here's the question, because this has been set for jury trial since May. This has been on the court's docket since April. So what was uploaded late?
It was about the complaining witness in a meeting that they had. There was a name that was mentioned in this interview with her that we have not seen before, who may have information.
And when did this interview with the complaining witness take place?
Your Honor, we met with the complaining witness last Tuesday. It was quite a very long interview with an interpreter with Mr. Caesar here. And that's when we received the information and we uploaded it over the weekend. And
this is what I don't understand, and maybe somebody can help me understand. I don't understand how a case is indicted and then the state is speaking to the complainant, a day before trial or a week before trial, and all of a sudden there's new discovery. I'm like, why is everybody waiting till the last minute to speak to a complainant? All ducks should be aligned and in a row. Maybe I did things differently when I was a prosecutor, but once I had and took a case to indictment to a grand jury, I received all the information, done all the investigative work. And if I met with a witness, I would tell them, this is the day we're going to trial. What you need to do is listen to the questions, answer the questions, and tell the truth. That was the extent of our meeting. I don't understand waiting and then interviewing a witness, then obtaining all this new information, then dropping it on the defense. And we're scheduled for trial. I don't understand.
Or Judge, in addition to my own reasons, I understand the state has a reason for themselves.
yes, Your Honor, I can speak to that. We do have an officer who is out of town starting tomorrow. As the court may or may not know, there was a translator needed for the investigation that was done. We were able to get a hold of that officer, and he is out of town and starting tomorrow.
All right. So as far as the state not having its witness, the state is not, the court is not going to grant a continuance based upon the state not having their witnesses. That witness, everybody knew this was the jury trial date because everybody was here when we said it. So, and then with the 404B?
Well, it was late notice. I haven't had a chance to go through that, Judge. I just saw I just got notice of the filing yesterday.
Well, has the law changed with 404B notice that can be given up until the day of trial? What's in the 404B?
And Your Honor, I can speak to that. It's actually stuff under 3837(1)B, which is just nature of the relationship stuff. It was a couple instances that the complainant described that described the nature of the relationship throughout.
Well, that's not coming in. So what's the next issue?
But
Any 404B that is related to their relationship, that's not coming in.
then, Judge, it would just
That
be,
was just dropped upon you.
it would just be my original. We had subpoenaed records for trial, and we don't have them.
When were the records subpoenaed?
Offhand, several weeks ago. I don't have an exact date on top of my head.
All right, so I need to know when the date the records were subpoenaed. Your other issue in your motion for continuance is that there are fears of immigration enforcement as it relates to your witness.
That's right.
Don't know what to do about that. There's going to be fears. So I can't grant a motion for continuance based upon a person's fears of coming into court. Now, if somebody wants to agree to have the witnesses by Zoom, you can, but otherwise I'm not giving a motion for continuance because someone is afraid of immigration consequences. Because if that's the case, then we will not be able to have a trial who knows when.
Thanks.
All right, anything else?
Not from the state.
All right, motion for continuance is denied. and state any 404B information that has to do with this defendant's relationship to the client. That's not going to be admitted unless the defense wants it admitted.
We understood, Judge.
All right.
Is there a time you like us to have that?
Yes, I'm going to have the jury's going to be out in the hallway by 11:30. I anticipate us recessing and doing jury selection at 1:30. All right, thank you. David Escobedo. Oh, I'm sorry, counsel. I'm sorry, Mr. Escobedo. Just have a seat. I'm waiting for your attorney to give the court information. This is 1:30. All right, are the parties still here on Pearl Gonzalez?
Yes, ma'am.
All right, so the email the court received from pretrial services that she is not in compliance. And what they sent me, they said, as of this writing, no, ma'am, she has failed to comply with pretrial. The defendant has not responded with us since 7/17, and multiple attempts have been made by her officer.
Thank you for the update, Judge.
Sure, no problem.
I know she's indigent. I believe it's a possibility of her being perhaps living on the streets. She was in custody more than 90 days without an indictment being generated, so that's what the PR bond did issue. So I guess if we could be heard on, I guess,
Sure.
they want to be heard on.
All right, the court is calling 2025 CR 008-155 State versus Pearl Gonzalez. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Renee Munoz on behalf of Ms. Gonzalez.
All right, this hearing was scheduled at 9 a.m. It is now 10:46 a.m. The court received a violation report that the defendant is out of compliance with pretrial services. According to the violation report, they state that she attended orientation and left, refusing to provide a UA sample to our office. For the record, both parties had no objections to the court emailing pretrial services to see if Ms. Gonzalez was back in compliance. And the email the court received is that the defendant is still out of compliance and has not been seen since July 17th, and they made multiple attempts to contact her. Defense, is there anything you wish to put on the record?
Yes, Judge. I know that she is indigent. She's being represented by the Public Defender's Office. And we believe there's a chance she may be homeless and otherwise unable to abide by the current conditions as set. We respectfully request that a summons issue in lieu of a warrant.
All right, state.
State requests judge's warrant, Your Honor.
All right, the court will issue a judge's warrant. Counsel, if your client makes an appearance, the court will reconsider. But for now, the court is issuing the judge's warrant and remanding your client without bond.
I understand. Thank you, Your Honor.
All right, thank you. Reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. State?
Your Honor, the reason that this agreement was struck with or offered by the state and accepted by the defense was because the offense date and for the offense that we're here for is February 13th of 2023. The defendant did have some additional felony charges for which she was indicted for in 2024. However, this case had not been turned into our office yet. And so regarding the 2024 indictment, she did take accountability and enter a plea on those cases. However, this case was still outstanding at the time. In that case, she had 255 days worth of credit in the Bexar County Jail that had this case been filed at the time she would have received credit for. And so I took that into account, and that's why we reached the agreement that we did.
All right.
That's correct, Judge.
All right, the court will follow your agreement, find you guilty, sentence you to $800 time and money to run concurrent. 2 days in the Bexar County 12 on 1244. There should be no contact with Freda Flores. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand people get upset with the way people are driving. And it appears from reading the police report, both of you were in the wrong. She was in the wrong for riding your bumper, almost hitting you. She was in the wrong for throwing, some sort of liquid at your vehicle. You were in the wrong and in a dangerous situation from getting out of your vehicle and striking her vehicle. You understand?
Yes, sir.
All of this could have been gone left, farther left so quickly, because if she would have had a gun, she would have ended up shooting you. And then everybody would say, well, was it justified? Was it not justified? Because she came at her vehicle with a weapon. You understand?
Yes, sir.
So what I've discovered is when you're driving, just have patience. Don't honk at anybody unless it's to say hello. And you know what my mom always told me? Let them pass. She's like, just let them pass. Your job is to get from point A to point B safely. You understand?
Yes.
All right, good luck to you. Have a great day. Court is calling 2025 CR 005379 State versus Adriana Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right. So it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right. So I don't do ex parte. However, managed assigned counsel just sent an email to the court coordinator, and the court is in receipt of that. Any objections to the court reviewing what managed assigned counsel has sent?
No, Your Honor.
All right. All right. So the email that has been sent to me, and I want to explain to you, Ms. Ramos, normally I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next counsel with any questions, Your Honor.
All right, if you will just remain in court.
Y'all will.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay. So do you have any money in a savings?
No, ma'am.
All right. So I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castillo. All right. So if you'll confer with him.
Yes.
All right. She's set today. We're off the record. She says today for it's just discovery today.
Okay.
So that's what we're here for.
Okay.
So he'll confer with you, and then he'll confer with the state, and then he can approach me when you're ready.
Yes, Judge.
All right, you're welcome.
See outside.
Hello.
Morning, Your Honor.
Good morning. All right. All right. Mr. Lopez, today is your plea deadline date?
Yes, Your Honor. I'm covering for Ms. Knowles this morning. When I conferred with Mr. Garahan, there's still some discovery outstanding, and they're asking the court to reset the plea deadline one time to allow the state to provide us that discovery.
Okay, what discovery is missing?
It's, Judge, it is actually missing. I looked on Veripic and they don't have the body cams on there, and that's what's missing.
Okay.
And I was unaware. The offer had been extended. I just was unaware until presently that I believe Caitlin Knowles was the main attorney on this. And I was just notified today that she had notified Mr. Solansky that.
All right, so When do you believe you'll have that?
2 weeks to 4 weeks, Judge. I mean, Megan Galloway has just emailed PCSO to obtain that.
All right, Ms. Ferguson. If you'll extend this plea deadline date for 30 days, there'll be no further extensions. All
Thank you,
right,
Judge.
thank you. What date? All right. August 21st. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused, okay? Thank you. Thank you.
Excuse.
Yes. All right, who's here on Adriana Ramos? Hello. All right, have you had a chance to meet with your attorney? All right, and defense?
Yes, Judge, I've met with my client, just assigned today. I need time to go through discovery. So I asked that we're receiving you a court date.
All right, Ms. Ferguson, on this, do 30 days for discovery and counsel. There's going to be a quick turnaround after the discovery. All right, August 21st, counsel.
That works, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome. David Moses Escobedo. David Moses Escobedo. Thank you. All right, the bond was reinstated. Why is he still in custody?
It is not showing that it's been reinstated, Judge. I looked online yesterday. I spoke with the bondsman. They said that they had agreed to it. I didn't think they filed anything.
Yeah, I've signed everything. It is 2025 CR 02743.
Honestly, didn't show any updates in regards to that.
Okay, because he should have been released.
Mm-hmm. 2743.
No, the bondsman sent something over. All right, you want to get in touch with the bondsman?
Okay.
All right.
They need to file something.
But they did file something. I remember asking that the bond be restored.
With that.
So if you can have them, Mr. Escobedo, just have a seat. If you can see if they can find it. Yeah. Michelle Battles. If you'll come forward, please. Hello.
Hi.
All right, so you were late for court. Here's the thing. You cannot be late for court. You've been here before. You know where the court is located. Other judges, guess what they would have done? Taking you into custody. Once you're late, you're late. You understand?
Yes, ma'am.
Court starts at 9 a.m. All right, state. Has an offer been tendered?
Judge, an offer was tendered on the cases that are indicted currently. She, as the court can see, she's got a number of pre-filed cases. The state checked this morning. There's no labs on those cases, so we would be asking the court to see if they would give us a little bit more time so we can try to encompass all of those cases. But just to answer the court's question, an offer was tendered on these specific cases, yes, but there's no agreement on these specific cases yet.
All right, Ms. Ferguson.
Yes.
On this case, I need a plea deadline date with the jury trial setting. It should be a short trial.
Yes, any of these would be short, Judge.
Okay. All right, your jury trial date and plea deadline date is going to be September 23rd. The court will not consider any plea bargain agreements after that date without good cause. Otherwise, you'll have to plea open to the court. Do you understand? You need to make sure you're on time.
Yes.
All right, once you sign the reset form, you're excused. And thank you for dressing appropriately for court.
Thank you.
You're welcome. Court is calling 2025 CR 003-633 State versus Yvonne Ordonez. Can I have parties announced?
Megan Galloway for the state.
Renee Munoz on behalf of Ms. Ordonez.
And are you Ms. Ordonez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there's no application. Ms. Ordonez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Ordonez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with criminal mischief, 2500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes,
Did you intend to give up those rights and enter into a plea in this case?
yes,
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
My opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Ms. Ordonez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 days in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor, and I can speak to the term if you'd like at the appropriate time.
All right, thank you. Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, sir.
Did you sign it in both places?
Yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, there is to be no contact with Freda Flores. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
yes, sir.
Then to the offenses charged, how do you plead?
Guilty.
State any evidence.
State offer states one in attachment.
No objection, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments
And
and
there it
review the.
is. A long day in Judge Boyd's courtroom ends not with a bang, but with a razor's edge balance. Structured probation, drug court, GPS tracking, parenting classes, restitution, and the ever-present threat of prison if she slips. It's a second chance, but one lined with landmines. What struck me most was Boyd's blunt advice. If the answer is maybe, don't do it. That's more than courtroom talk, that's life advice. Now I want to hear from you. Do you think Judge Boyd's decision was just? Did he strike the right balance between justice and mercy? Or did he gamble too much on someone with a history of lies and relapse? Drop your verdict in the comments. And if this case stunned you like it did us, smash that like button, share your verdict below, and subscribe for more explosive courtroom breakdowns every week.